right, I will now call this session of the Senate Judiciary Committee to order. We have everybody here, and I want to thank the hardest working staff in the building, the Senate Judiciary staff, for making this meeting work despite our very crazy schedule this week. And with that, will the esteemed secretary please take the roll?
Vice Chair Cannizzaro.
She is on her way. If you'd mark her present when she arrives.
Senator Orenshaw.
Here.
Senator Harris.
She is also on her way. If you'd mark her present when she arrives.
Senator Sotomayor. Here. Senator Hansen. Here. Senator Pickard. Here. Chair Scheibel.
Here. Thank you. All right. Looks like we have a full house today because the building has reopened even more than last week, and it is very nice to have so many people here. Ground rules are the same as always. We will do presentations first. Members will have a chance to ask questions. Then we will do testimony from people in person in support, then via phone in support, in person in opposition, via phone in opposition, in person neutral, via phone in neutral. All that testimony is limited to 2 minutes per person, and that is a maximum, not a minimum. Don't feel the need to hit 2 minutes. You can say, I agree, ditto, I'm on the same page, and we will register that as your opinion as well. With that, I think we are ready to go ahead and get started with our first item on the agenda today, AB 116. And I will now open the hearing.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. For the record, I am Assemblywoman Rochelle Wynn, and I am representing Assembly District 10. It is my privilege to present to you all Assembly Bill 116 for your consideration. This bill seeks to change our current system for minor traffic and other related violations from being criminal to civil in nature. Presenting with me today on the Zoom is Erica Ferris, one of my wonderful, diligent, and just super intelligent and excited interns for this session to provide some background information on Assembly Bill 116. Additionally, I have Lisa Mosley here to answer any questions that the committee might have that I am not able to, so she's my lifeline. And with that, with your permission, Chair, if we can turn this over to Ms. Ferris, who is on the Zoom.
Good afternoon, Chair Scheibel and committee members. For the record, my name is Erica Ferris, and I intern for Assemblywoman Wynn. Today, I will be helping Assemblywoman Wynn present AB 116. Let's consider the following scenario. Many Nevadans are now living paycheck to paycheck, or worse, struggling with unemployment. An unpaid ticket for speeding, a broken taillight, or improperly changing lanes can make a challenging circumstance go from bad to worse very quickly. Inability to pay the ticket, followed by a failure to appear in court, constitutes a bench warrant. If arrested, even 1 to 2 days of jail time could lead to loss of employment, loss of housing, and in some situations, children taken away by Child Protective Services. Some even claim these minor traffic offenses are used as a vehicle for deportation for undocumented residents. The scenario is very real and tragic for so many of our friends, neighbors, and coworkers. Most states, including all of our neighboring states, have transitioned to a system that treats minor traffic infractions as civil offenses rather than criminal. These states have experienced not only reduced financial burden for those receiving citations, but also reduced costs associated with criminal proceedings and detention, as well as decreased burden on court dockets. Nevada is one of the few remaining states clinging to an outdated model where all traffic violations are processed as criminal offenses. This measure has been a long time coming in our state. In fact, there have been a number of bills proposing this change to the system since 2013. Unfortunately, we did not have sufficient support to move forward. In 2017, an interim study was approved to examine the complexity of this subject. It is our hope that we have learned lessons from that study and the 2019 session to gain greater support for AB 116 during this legislative session. Thank you, and I will now turn the bill presentation back to Assemblywoman Wynn.
Thank you. With your permission, Chair, I would like to kind of walk through generally some of the sections of Assembly Bill 116, as well as the amendments that I believe were posted to Nellis. There's a mock-up that was on there. Assembly Bill 116 establishes civil penalties for certain traffic and related violations. As you can see, if you look back at the history of this on Nellis, it started off with a bill that actually passed out of the Assembly in 2006 or 2019. I like to think fifth time's the charm on this bill, but I know that there has been a lot of work that has been brought forward in bringing this bill by people before me, so I feel like they've done a lot of trailblazing that has made it a lot smoother of a transition this time going through the bill. We were very well aware of some of the concerns that our partners, whether it's law enforcement, prosecutors, defense attorneys, members of the community, our court system have wanted to be a part of the conversation, and luckily I feel like we have conveyed a large group of stakeholders to make sure that we put this bill in the best position forward. And I believe what we have here today before you all is the best version of this bill that we've had in a long time. I know in meeting with clerks, court clerks from around the state, when I met with them on several different occasions, I was shocked to learn that I was the first legislator that ever reached out to them to get their opinion on how to implement like this type of change in our policy. So I really truly appreciate being able to work with those people in the rural communities, in the court system, the police officers that are on the field to make sure that this bill put forth a policy that was not only something that we could implement, but something that was smart. What I learned in my work and other forms of criminal justice reform is that we need to have policies that make sense, that are evidence-based, that take into consideration all stakeholders, and hopefully that's what this bill represents as I present it today. Assembly Bill 116, again, establishes certain civil penalties for certain traffic. As you can see, we've excluded any serious traffic. They are enumerated. They include things like DUI, reckless driving, hit and run. Additionally, a violation of a provision of an existing law or ordinance would be a civil infraction, not a misdemeanor, unless, again, a criminal penalty is prescribed for that. So that would include those more serious I would call them criminal charges and not traffic matters. Again, the main purposes of this bill is to make sure that we are not arresting and incarcerating people for committing minor traffic violations, especially when these individuals do not have the resources to pay for these tickets or fines. And I would say that a lot of people don't realize that they have committed a criminal misdemeanor when they've got a speeding ticket. I'm sure all the members of this committee have never received a misdemeanor citation for speeding because I'm sure they are all following those traffic laws to a T. And yes, I'm looking at you, Senator Hansen. So I think this is something that people don't realize. We have people that are coming in, they are tourists. I think most people this is premised on the belief that most people want to pay their traffic fines, and they don't realize whether or not they are traffic infractions or they are civil infractions or criminal infractions, but our system is burdened by that fact. If we start with sections 9, 11, and 12, it does make it clear that civil infractions still count as infractions on a person's driving record. One of the things that I wanted to make clear is that by decriminalizing traffic, minor traffic, that we didn't compromise public safety. We didn't compromise those types of aspects. So that makes that clear in those sections. Sections 23 through 26, again, explain the procedure of how these cases would now be processed through the court. Section 24 provides what notice the civil infraction would be and what it would look like in terms of the field and how it would be handled in the field by any peace officer. And again, Section 26 makes it abundantly clear that police officers can still stop you if you are committing a civil infraction, and they can detain you for a reasonable amount of time to investigate. What I didn't want to do, like I said, with public safety is take away that aspect of public safety, take any of that like discretion from police officers. If they're pulling you over for a speeding ticket and they pull you over and you roll down your window and they're going to give you a civil infraction and they see a severed head or they see, they run, your license, they feel like you have criminal warrants, they can still arrest you. If you smell like alcohol, they can still detain you. If there are any other indicia of like part of their investigation, they can still do their job. They can still keep our public safe. If anything, reducing these criminal cases from a criminal case to a civil case reduces that burden, and it reduces the burden on our police officers to have to come in and testify in a speeding trial in court. In talking with numerous prosecutors across the state, instead of prosecuting a robbery charge, they are now putting on a speeding trial. And this reduces the burden from that reasonable doubt that you get when you are charged with any criminal prosecution down to that preponderance of an evidence, to the point where an officer no longer has to come in. If they choose to, they can submit an affidavit, and that would be sufficient for the judge to, or the master, hearing master, or whoever is adjudicating that civil infraction, to use that in consideration in determining whether or not that standard has met. Additionally, Section 30 basically says that if you are faced with one of these civil infractions, you have three options. You can pay the fine and be done with it, you can contest the citation, or you can acknowledge the infraction was committed but explain mitigating circumstances. Again, Sections 31 through 33 describe what that hearing might look like in court, and Section 80 would require that any existing warrants for failures to appear in court would be canceled. It doesn't mean that the ticket would go away. It doesn't require all of the existing criminal-like citations to be now converted retroactively to this. It just means we can no longer arrest. I will tell you that across the state, I would say a lot of the jurisdictions have moved towards this model where they are not arresting people. We heard here in Carson City, and this is part of what inspired me to bring back this legislation for the fifth time, is in at the end of the 2019 session, Carson City kind of saw where perhaps we were going as a state to catch up with the other, how many is it, 40 states or 37 states that already have decriminalized traffic, and they decided they were no longer going to arrest individuals for these charges. They were no longer going to look at it. They looked at it this holistically. They determined that when a police officer stopped someone and they had a traffic warrant for failing to pay their speeding ticket, it took that officer off the streets. They now had to impound the car. They had to take the officer had to arrest the person, take them down, book them in. They had to be booked into their system. They had to spend on average 72 hours in custody. And then they were released a lot of times with credit for time served for that bench warrant and that fine. So they weren't collecting the money, they were only outputting money. They learned that when they reported this to a collection agency, they actually saw an increase, I think it was around 8.5% in the amount of money they were actually collecting for these warrant fees. So, and that was during a pandemic when they already saw the loss of tickets, the number of tickets went down. So these are all things that I kind of took into consideration. If you look at the amendment that is in the mock-up, it is the proposed amendment 3425 to Assembly Bill 116, the second reprint that is on Nellis, and hopefully you had the opportunity to see. One of these came from NACO, which has been actively working with us, especially some of our rural jurisdictions, to make sure that we are giving as much flexibility as we can. To put that in there, I think there's still some wordsmithing that can be done. I learned recently that badge number isn't always something that is stable. So we are open to being inclusive on what that might look like as well, inclusive of the badge number or any other identifying number that the peace officer issuing the citation might have. It also includes other aspects of establishing a dispute resolution to just give those local jurisdictions more flexibility. Additionally, we accepted an amendment from the Clark County District Attorney's Office that they had submitted to us regarding Section 79.2. Again, this was a section that was inadvertently left out that also included, again, a person may be detained or encountered under circumstances where they have committed or are committing a crime or a civil infraction. So that gave the officer the ability to stop someone for that civil infraction and detain them while they are doing that. And with that, I will turn this over to Ms. Mosley. I don't know if she has any statements to make or if she just wants to answer questions, but I will turn it over to her with your permission, Chair.
Thank you, Assemblywoman Nguyen. Lisa Mosley, that's spelled Leisa Mosley. I am the State Director for the Fines and Fees Justice Center. The Fines and Fees Justice Center is a national organization that works to end fees that are associated with the criminal justice system and make fines more equitable and just and proportionate to the offense. We are in support of this bill. It is an honor to sit beside Assemblywoman Nguyen and present with you and answer any questions that you might have. So with that, I look forward to any questions that the committee may have for me.
Thank you all so much for your presentation. Do the members of the committee have any questions? Senator Harris.
Thank you, Madam Chair. No questions, just a comment. It is well past time that we get this done. Thank you so much, Assemblywoman Nguyen and Ms. Mosley, for your work on this, and I look forward to voting this bill out of committee and on the floor.
Thank you for that. Other questions? Senator Pickard.
Thank you, Madam Chair, and thank you for bringing the bill. I mean, we've been talking about this for as long as I've been here. I just have a couple of questions or a couple of thoughts. First, the first several years, 8 or 9 years of my law practice, I handled tickets for free for clients and others that would come in. And it was amazing to me how easy it is to settle a ticket. And, for an attorney, you walk in, and this is down in southern Nevada, whether it's Henderson or the county or municipal, Las Vegas Municipal, you walk in. There's a long queue. Not all are attorneys, but you walk up to the table, you get the charging document, you wait in line, they call your case, you stand up. I don't have to say anything. They just confirm that I'm there for this person. They assess the fine, reduce it to a parking ticket, and say, get out of the way for the next person. So it's incredibly easy right now to resolve these tickets. And yet what astonished me was I would get people calling and say, hey, I just found out I've got a bench warrant outstanding, and I've got 30 tickets I need to resolve. Okay? And I'd say, well, why didn't you show up? This is an easy system. And they usually had some excuse that I may or may not have believed. But at the end of the day, these are people who have flouted the rules. They've got a bunch of tickets. They've gotten ticket after they missed a deadline, and somehow I think the bench warrant probably wasn't yet issued, but they got another ticket. The people that are typically exposed to bench warrants, in my experience, were those that probably deserved a little bit of accountability. But that's not what this is about. I'm assuming because we're moving from a criminal to a civil action, we're also moving from a beyond a reasonable doubt to a preponderance standard. I see a nod. So with that, are we also then reducing fine? I mean, not in this bill, but is the expectation then that the fines are going to be reduced, or how does it work? What's the downstream effect after this bill?
Rochelle Nguyen, for the record, thank you for your question. You must have incredibly good staff at your office, but I will tell you, it has not an easy solution for people to resolve their tickets. I can tell you that by the number of tickets that I am asked to resolve for attorneys that don't know how to figure out the various systems. In Southern Nevada, there are different systems in place for attorney resolutions, to put it on an attorney calendar where you're represented by counsel in the city of Las Vegas, the city of Henderson, Boulder City. There are some places that you fax like your request on what you want things resolved for, and that's an attorney being able to do that. What we've shown, and what Ms. Mosley can probably speak more to, is that the number of warrants aren't necessarily yes, there are people that flout the law, that are going to just be habitual, like, traffic offenders. Any one of these prosecutors that are behind me that I know that will come up and testify, either in support, neutral, or opposition, they will talk to you about those people as well. But the vast majority of those bench warrants, the vast majority of those people that are going into warrant not because they don't want to pay, is sometimes they don't have the ability to pay. So to the first part of your question. The second part of your question, baby steps. We have to start here. Yes, I think having conversations about the amount of fines, the way you pay fines, the way you do that is another policy conversation that we should have. And if I'm fortunate enough to be here in 2023 and this bill passes in this legislative session, I am sure I will be back here having those same kind of conversations about how we continue to move forward and progress and make our system a fair situation. And yes, it is a preponderance of the evidence.
Lisa Mosley, I'd like to, Fines and Fees Justice Center, I'd like to, if I may, Chair, through you, address Mr. Pickard. I'd like to offer some insight onto how people end up with warrants. But the first thing I'd like to say is that there's nothing in this bill that would allow people to break the law with impunity. The fines don't go away, the fees don't go away. People still have to pay those fines and pay those fees. The only thing that this bill does is keep people from being arrested for being unable to pay those fines and fees. How people end up with warrants, you're right. You can walk into, when you get a citation with a court date, you walk into the court, and most jurisdictions, you don't go before a judge, you go to a window. There are some where you still go before a judge, but in most cases, you go before a window. One thing is supposed to happen. In 2019 session, AB 434 was passed. Senator Harris worked very diligently on that bill. That mandated an ability to pay assessment that all the courts are supposed to use before adjudicating any traffic fines. If a person is unable to pay right away, they are offered the ability to go on a payment plan, and they are offered community service. That's what's supposed to happen. So that's the beginning. If someone says, I'd like to get on a payment plan, they are now assessed a payment plan fee. In addition to the original fine and the original fees that come with that, they now have a payment plan fee. So let's just say the person is paying their fees. They're paying their fine, they're moving along. Then comes a payment day. And let's say your payment is due today, but they don't get paid until Friday. There is no grace period in Nevada. If that person doesn't make their payment today, by 12 midnight, they are in warrant status. So warrants don't just get issued because someone just says, I'm not going to pay. They get issued because someone may have missed a payment, which we see quite often. The other thing is, if someone misses a payment, there are some jurisdictions that code that as a failure to appear, as well as a failure to pay. So that's how someone ends up in warrant status. And I just wanted to add that in there because the system is premised on the fact that the belief that people are scofflaws and they just don't want to pay. But what we have found with research is that is not the case. When the barriers to paying fines and fees are removed, people actually will pay. That is evidenced by the fact that Carson City, when they removed those barriers, saw an 8.5% increase in their annual collection rate. There's another point about Carson City that we don't talk about much. Not only did they see an 8.5% annual increase in their collection rate, of the cases that were turned over to collection agencies, which is what this bill will allow jurisdictions to do, they saw a 50% increase in the collection of cases that were turned over to collections agencies.
All right, and you touched on my follow-up, which was a standard process, because you're right. Las Vegas Municipal has a different process from Las Vegas Justice Court, from the county process, from Henderson. Henderson is the one where you fax it in, and that's good enough. But and it's been a couple of years since I did maybe a year since I've done a traffic ticket. But as I'm sitting waiting for my adjudicatory process to finish, I'm watching the pro se's stand up, and if they're asked the question, can you pay this? They say no. Would you like a payment plan? They say yes. What day would you like to start your payments? What day? They ask, what day do you get paid? And so they go through all the things you just described. And my guess is they have a pretty good result, but there are going to be those that that don't pay. So, obviously the bill doesn't address standardizing the practice, which I think would be very helpful. But how do we, I'm trying to narrow the focus right now on those after this bill is enacted, because I think it will. I ultimately support what we're trying to do here. I would like to see it go a little further. But how do we then incentivize payment? Because the ability to pay is somewhat subjective. It's, do they have the ability after all the other things they want to pay for is usually, at least in my experience, that's usually the last thing they want to pay, so they run out of money before they pay it. How do we incentivize payment? Because that's ultimately the teeth to our traffic enforcement. If we're going to remove the criminal penalty, how do we incentivize payment and thus accountability? And I won't tell you how many tickets I probably have deserved myself.
Lisa Mosley, I'd also like to point out, Senator Pickard, that over 80% of warrants in Clark County were issued to people that have a median income of under $49,000. So what we often see is it's not a case of people not wanting to pay. It's a case of them having the ability to pay. By the time someone purchases food for their children, pays their rent, pays their other bills and things that are absolutely necessary, like their lights, like their gas, like putting gas in their car. Sometimes people just don't have the resources at the end of all of that to pay a fine. How do we incentivize this? One, we take away the ability for them to be arrested for not making a payment. Two, we make the payments reasonable. We take away the fee to establish a payment plan, because depending on what jurisdiction you're in, it could range from anywhere from $50 to $100. Now, perhaps for the majority of us sitting in this room, $50 is not a lot of money, but I can speak to you from my very own experience with this issue. As a mother of 4 young children going through a divorce, that $50 went a long way. Ask me how much a gallon of milk costs for my children. Ask me what a loaf of bread costs. These are the people that we're talking about. There are going to be some folks perhaps who just forget they have a ticket or don't pay it. But the research does not show that. The research shows that people simply do not, at the end of the day, have the ability to pay. All we're doing with this bill is asking, one, that people not be arrested, because that just creates more harm for them and creates more fees that they're not going to be able to pay.
And Rochelle Wynn, for the record, it also takes a huge financial burden off of the system to be able to arrest people, take away, we've heard on average it's $72 for those that have sat on this committee, listened to presentations by NDOC or even, different various detention centers, or if you sit on any of the money committees, you've heard that those average costs that they are seeking to incarcerate people range anywhere from $130 a day to $196 a day. I think those are the range that I've heard from the various agencies that actually are paying for those costs. So I think that's it. I understand your concern about, I guess, what would be the incentive. And like I said, I think a majority of people don't realize that criminal aspect is even there. I don't think they realize that. I will tell you, probably I will be back here having to address this as well, but right now the idea of being incarcerated as being somehow is incentivizing people to pay their tickets I don't think the evidence supports that is the case. If anything, sending someone to collections, putting that hit on their credit, suspending their license, those are all things that are really going to incentivize people to pay their tickets. In addition to that, some of the things that we looked at that we incorporated into this bill were things that in practice the courts wanted. They didn't want to have to constantly send out certified mail to people to notify them. This allows them to take advantage of technology that we know has been successful in other aspects of notifying and reminding people of their tickets, whether that's sending an email. So there's an opt-in like on the ticket where you can put your email or receive text messages, because for some people, they sometimes will just forget about the ticket and unknowingly go into warrant. And if they had like a text reminder with a link to say, hey, pay your ticket here, they might be able to just do that. I mean, there are some people that would be able to pay the ticket when they got the ticket at the, like, you know, if our officers were now like collecting money, they could probably do that as well. So this gives them, the courts, the flexibility. As far as making like a uniform system across the board, I understand the like desire to do that. I know that we have so many differences in the courts, in the jurisdiction, that was something that I really wanted to be mindful of. What they are doing in Clark County, or what they are doing in the city of Henderson, and what they are doing in Sparks, and what they are doing in our rural communities may be a very different situation. So I wanted to still give those jurisdictions the flexibility. As part of some of the funding, we changed some of the funding to go around, so more of it stayed locally with those jurisdictions, so they would be able to, whether it's right or wrong that we fund a lot of our like court system based on these traffic fines and citations is a whole separate conversation. But I know that's the reality of what these courts and what these jurisdictions are undergoing right now. So we made all those efforts to make sure we were not, we were accommodating some of those things. So I hope that kind of answers some of your question.
Yeah, no, and you've addressed it somewhat. I mean, I'd still like to know what the downstream effect is. I think it's interesting. We're considering a different bill where people get paid every day, but we're going to allow them a daily or a transaction fee, which we do see on the payment plans. But some of those payment plans went down to $10 a month. It was whatever you could afford. We just want you to be responsible. And generally speaking, those that were agreeable and showed up would agree to those. So I kind of reject the idea that a small transaction fee is necessarily onerous, given we're considering the same thing. But I'm still, my concern is this, and I kind of spoke to it already, that my experience, anecdotal as it is, suggested that the bench warrant was very effective to a certain population, that they wanted to stay out of jail. Of course, I opposed the idea of pulling their driver's license, suspending their driver's license or their vehicle registration, because now we're eliminating the ability for them to get to work and feed their families. So, but it's the more we reduce the accountability, the less incentive there's going to be ultimately to pay to that margin that doesn't want to pay anyway. But anyway, I think we've hit enough of this. I don't want to take any more time. We got more to do today. But thank you. I appreciate your response. And I do appreciate all that you've done to make this easier for the municipalities and the justice courts to resolve these things and get them through the system.
And there's plenty of exhibits on Nellis, and I'm sure Ms. Mosley could wax poetic for like hours on the evidence-based in some of the studies that we've looked at, including right here in Carson City.
Thank you. Senator Orenshaw.
Thank you, Chair. And I want to echo some of the other colleagues who spoke. Thank Assemblywoman Wynn, Ms. Mosley, for bringing this bill. I, too, have sat in certainly, I think, along with Senator Hansen, Assembly Judiciary Committee, where we came very close to trying to take this action, and somehow we just, it didn't happen. It seemed like there were just too many impediments. It couldn't make it work. So I think this will, change so many people's lives. And I just wonder, under the current system, I've got to imagine a lot of, with transiency and folks having to move around, that a lot of mail doesn't get to them, and a lot of folks may not realize that something has gone to warrant till they're stopped, and then aren't going to get to work the next day because they're a guest at the county jail. So I don't know if there's any data about that, but I've got to imagine that there's a lot of bad addresses in the system that the notices go out to, and people just really aren't getting good notice. So it's kind of a comment more than a question, but I really appreciate the bill. Thank you.
Other questions from, all right. Then I have a couple of comments and questions as well, because I do support this bill. I think it is, as my colleague Senator Harris said, long past time. And I'll also, there are just a couple of things that I wanted to point out. Not that your presentation was not thorough, but in my experience, everybody knows I'm a prosecutor in my day job, and in my experience, a lot of these cases or a lot of these tickets are for issues that are originally caused by not having the money to solve the problem. An out-of-date registration, a broken tail light, a failure to signal, which is actually caused by a broken blinker, those kinds of things. And so people get stuck in this cycle. And also I can only speak to my experience. I don't have the numbers, but in my experience, I have definitely encountered people who come into court in custody because they've been arrested on a traffic bench warrant. In that case, they're not necessarily entitled to an attorney. They're only entitled to an attorney if the state chooses to seek jail time in those cases, which means that for the most part, I am interacting with those people directly as the prosecutor, as opposed to working through an appointed attorney. Often our fantastic public defenders in Clark County will stand in as what we call a friend of the court, so that they can have a conversation with those people. But the point I'm trying to get to is that I have never, ever, even once in my experience, encountered somebody who said, "Oh wow, I could have paid this. I was just avoiding it. I knew there was a warrant and I got caught." That has literally never happened. I've run into people who said, "I had no idea I had a warrant out." I ran into people who said, "I tried to quash this warrant, but I didn't know how." And I ran into people who said, "I've been fearing this day for years because I knew that my traffic tickets were accumulating, and I always warn my kids, if we get pulled over, be ready to call dad or be ready to call Aunt so-and-so because mom probably isn't going to be able to take you home if we get pulled over," because they knew that warrant was out there, but they didn't feel like there was anything they could do to stop it. So I don't think any parent or any person should ever be put in that position. And so my questions are really just technical and more out of curiosity than, weighing on my support for the bill. But if somebody was in the position of having 2 or 3 or 4 tickets and they knew about them under the new system, there are civil penalties, they want to resolve them, does this empower the local jurisdictions to assign the responsibility to any number of people, like the clerk or the hearing master or the judge, to have that one-on-one conversation with the person and say, "Hey, you have 3 speeding tickets, we will dismiss the 1 if you pay the 2?
Rochelle Wynn for the record. I'm not sure what section it is. Obviously, it's a very lengthy bill, and I'm sure if someone knows that and they come in and testify, hopefully they can answer that if they're very familiar with it. We did try to put as much flexibility in there to allow the courts. We worked really closely with the courts to try to get to a position where we gave them flexibility, whether or not they wanted to continue to have prosecutors still presenting and prosecuting the cases, whether or not they wanted to have a court, a judge, a municipal court judge, a hearing master, a traffic ticket window person, like Ms. Mosley had said. Most people are not going before a judge. They are going before a traffic a clerk at the window. So there's still that kind of flexibility that still exists for these jurisdictions. Again, it just turns it in from a criminal citation to a civil citation. As far as those people that are repeat offenders, again, one of our big concerns was traffic safety. I don't think criminalizing it makes us any less safe. Otherwise, we wouldn't be one of 11, how many states? 13 states that have not decriminalized traffic. So I would say that our neighboring states that have decriminalized, the rest of the nation really, that they are not any less safe because they have done this. And I think that's where we look at the evidence to show that that's not the case. And so there is still that flexibility for them to be handled by various within the court system.
So for example, they might do what the city of Las Vegas I heard from a friend does, because this friend got a parking ticket, and when this friend called the office, they were like, yeah, we can't do anything over the phone, but if you come down to the window, you can talk to a clerk. And then that friend went down and talked to the clerk, and they were like, yeah, you waited too long. We're not going to give you a break. You need to pay your $20 parking ticket. So that would be basically the same thing could happen now with a speeding ticket or a failure to yield or rolling a stop sign.
Rochelle Wynn for the record. That's actually a very good example in the city of Las Vegas because their parking tickets are actually civil infractions and they go through a different court system through the they don't go through a court system, but they do have those due process protections and they are done through the city of Las Vegas and not within the city of Las Vegas municipal court. So, you know, they've done this in other areas when it comes to traffic tickets, but when it comes to, you know, a speeding ticket, it goes into that criminal world. And just so you know, a speeding ticket, you know, 1 to 10 over is the same as like a battery domestic violence first offense. It is the same as a DUI. It is the same as an assault or a battery or, you know, a petty larceny. So all of those things carry with them the same penalty of up to 6 months in custody. You can look at some of the jurisdictions in Clark County in particular, and if you go onto their jail, like, you know, the public record, it will say serve or pay. So we know exactly how many people are serving or paying. And I know that we don't have a debtor's prison, but it sure does appear like it when you have a serve or pay like listed on the website. So, you know, hopefully this bill will curb that ability and save our taxpayers a ton of money and perhaps even bring in money. Like I said, 50% increase, you know, for those that were sent to collections. I mean, that seems pretty substantial.
Lisa Mosley, we have mentioned speeding tickets as an example quite a bit. However, in Clark County, of the 88% of warrants that were issued, 58% of those warrants were for administrative issues. They had absolutely nothing to do with driving. They were issued to people for having an expired registration, not having proof of insurance in the car, not having their driver's license on them. Those are the things that people are getting tickets for that are going into warrant. It has nothing to do with public safety. So in issuing warrants for those kinds of tickets doesn't make our roads safer. In fact, it takes our officers off the street from enforcing more violent, a serious crime, and makes them traffic officers. So I just wanted to point that out.
Thank you. I think that is very informative and very helpful for all of us to understand the scope of what we're talking about, that there are, you know, there's a large group of people who are getting caught in this net because they are struggling financially to begin with. There's another smaller group who are stuck in this net because they got one speeding ticket, and then there's the rest of the net, which are people who are in the, you know, fortunate position to be able to pay a speeding ticket and move on. I understand that some of my colleagues have some questions. I just have one more question, which is about like the record keeping. So would these would these existing citations, existing tickets still show up in a law enforcement database or just in the courts database? Basically what I'm wondering is if somebody got pulled over and so now they don't have a warrant, would the ticket even show up when they get pulled over?
Rochelle Wynn for the record. Like I had said during my presentation, some people know, some people on this committee might know, if you get a traffic ticket, there's like points that are reported to the DMV. I'm sure Senator Pickard knows. Part of the reason people want attorneys like us to come in and handle tickets is they're like, I don't want to do the traffic school. I don't want to get the points. I don't want the points on my insurance. And that's like, you know, the concern for people. Under this bill, we're still able to maintain that point system. So if you get so many points, the DMV can still suspend your driver's license. So despite the fact that this is now a civil infraction, you can still lose your license because you're a terrible driver. You know, police officers can still pull you over because you're a terrible driver and you're speeding and you're like, you know, causing like a safety issue. They can even still pull you over if you have a broken taillight, which is arguably a safety issue concern, no matter what the reason is behind, you know, that. it drives me crazy when people don't use their turn signal. And you should be pulled over and cited civilly for failing to use your turn signal when it creates a safety issue. So all those things are still in place, and so there is still that protection there for our public safety.
Thank you very much. And the question that arose on the Senator Settlemyer.
Thank you, Chair. I appreciate it. I'm not as familiar with some of the other areas, but I know up in Reno and so forth and down in Vegas, you guys have meter readers. People that are basically reading the meters and things of that nature, and they're always limited to just being able to find citational type offenses. So would this bill allow them to find more types of offenses? Just curious.
Rochelle Wynn for the record. I don't believe so. I think we still are maintaining them as like civil infractions. So I don't think you can have a meter reader that pulls someone over for speeding, for example. That's not the intent of this bill. The intent is to allow, our peace officers to be able to still, protect the public safety when it is necessary to pull people over for traffic violations. It still allow them to be able to complete any investigation if there is deemed necessary based on that stop, if it goes further than just the civil infraction.
I appreciate that, but in that respect, I wouldn't mind finding out, just out of curiosity, yes, we're, meter readers are always limited to just giving citations. If we're going to make everything a citation, doesn't that then, by definition, allow them to write things if they observe them and want to go ahead and give that person a citation? Just curious.
And Rochelle Wynn for the record, I will look at it. I'm not sure exactly what the definition is of who can impose these civil infractions. And again, if there's someone out there, another lifeline, they might be able to point to that section. I'm sure it would be, I see Mr. Callaway behind me, so he might know what section that's in. And that's the benefit of having the reflective plexiglass, as I see who's behind me. And so I can call on them and be like, I know who has the answer to this potentially. So I would ask anyone out there, but I will follow up with you, Senator Settlemyer, if I can find that section before the end of this presentation.
All right. Well, it looks like this presentation is coming to an end because we've exhausted the committee's comments and questions, which means that it's time to move on to testimony. As I stated earlier, each person will be permitted 2 minutes maximum to speak. Now that we are in person and I don't have a queue in front of me, I'm not quite sure how many people I have. So I will try to get through everybody. But I'll give you a warning if it looks like we're not going to be able to do that within a reasonable period of time. So we will start with people in person to give support testimony on AB 116.
Hello, and thank you, Chair. This is Nick Shepak, Policy and Program Associate with the ACLU. We want to thank Assemblywoman Wynn for bringing forth this important piece of legislation once again. We think this is the year we can get it done. The criminalizations of traffic tickets is a major issue in this state, an issue that we can fix this session. It's a racial justice issue with 2/3 of Las Vegas traffic warrants going to people of color. It's an economic justice issue with those who are have the least amount of money being the most likely to be issued these types of warrants. It's a criminal justice issue, as early contact with the criminal justice system and time spent in jail is a major indicator of future contact with the criminal justice system. It's a public safety issue, as our hardworking law enforcement officers are spending time issuing and arresting people on bench warrants for very minor traffic violations. It's a budget issue, as it's a taxpayer who pays for the courts to file these warrants, law enforcement to enforce these warrants, and jails to house people on arrest for these warrants. It's a public health issue, as potential medical school students who live in the state of Nevada can have criminal records from these very minor traffic violations, as opposed to all of the neighboring states where a student who is applying for medical school who is less likely to practice in Nevada won't have a criminal record and it won't show up on their background check. And it's a child welfare issue, as single parents who are arrested on a traffic warrant can spend 2-3 days in jail. Their children are removed, even if they get them back, which most will. That's a very traumatic experience, especially for a young child. This issue has a wide impact. It impacts Nevadans across the board. We urge you to pass this bill in its current form. It is way past time, as we've heard multiple people say, and I thank you for your time today.
Good afternoon, Chair and members of the committee. For the record, my name is Christine Saunders, and I'm the Policy Director at the Progressive Leadership Alliance in Nevada, here in support of Assembly Bill 116. For many people in Nevada, the first step into the criminal justice system is a traffic stop. And because Nevada's traffic tickets are currently criminal violations, something as seemingly harmless as a broken taillight or unpaid parking tickets could lead to your arrest, incarceration, or as you've already heard this session, the suspension of your license. We know that the fines associated with these infractions are outside the means for many Nevadans. A recent report by Edelman Financial Engines found that nearly half of American households with incomes less than $50,000 report having no money set aside for an emergency. Similarly, when the households in this range were asked how they would cover a $400 unexpected expense, only 41% say they would pay it in cash or pay it off on their next credit card statement. The rest would resort to borrowing, debt, or raiding their retirement savings, and 1 in 5 say they would be entirely unable to come up with the money. By making minor traffic violations civil infractions, we remove the overly harsh punitive measures and prevent the physical, emotional, and economic harm that being incarcerated can have, such as losing employment and housing instability. Most of Nevada's neighbors have already taken the step to decriminalize minor traffic infractions, and we believe it's time for Nevada to join them and urge your support. Thank you.
Thank you, Chair Scheibel, members of the Senate Judiciary Committee. My name is John Jones, here on behalf of the Nevada District Attorneys Association, and we are in support of AB 116. And I want to start off by thanking Assemblywoman Wynn for bringing this bill and working with us, starting in the interim on this issue. We've had several conversations about this bill between Assemblywoman Wynn, myself, the public defenders, and I think we've got a piece of legislation before you that will truly work to the benefit of all in this state. In the discussions that the legislature has had over the last few years about criminal justice reform, it appears that we have ignored the most obvious candidate for reclassification, that being our traffic system. We are talking about low-level, minor traffic offenses like speeding, crossing a white line, and having your tail light out. As has already been testified, it surprises a lot of people to learn that they're committing a misdemeanor offense when they commit one of these infractions. Now, there are several traffic offenses, DUI, reckless driving, hit and run, that should remain criminal, and they do in AB 116. But the large bulk of these current misdemeanor crimes can be reduced to civil infractions with little to no impact on public safety. And with that, Chair Scheibel, we are in support of AB 116. Thank you.
Hello, Chair and members of the committee. My name is Maria Teresa Lieberman Barraga, for the record, and I'm here representing Battleborn Progress, and mostly myself. I am one, before I was lucky enough to have a good job, I experienced what presenters and the chair talked about. I got to see my mom a couple of times have to figure out how to deal with a traffic ticket for something very simple. And the reason why it was very difficult was because, one, she was a housekeeper that worked 2 housekeeping jobs, not just 1, 2. And her days off were always scattered, and sometimes she wouldn't even get a weekday off to actually be able to deal with it. Other times, it was because at the same time, when she got those couple traffic tickets, we were applying for citizenship. And if you've never gone through that process or know someone that's gone through that process, it's an expensive process. Each form for citizenship applications can cost anywhere from $90 to $500 to $600 each. And I had to have conversations as a preteen and as a teenager with my mom, because she was a single mom, about how do we budget so that we can make sure she gets her ticket dealt with and doesn't get criminalized for it. And how do we also become, citizens and stay on track for that, because that has its own deadlines and that has its own process it goes to go through. And they were difficult conversations, and I guarantee you there's probably lots of folks that have had those same things, and you want to be responsible and do both, or whatever responsibilities you have. And it's just not easy when you have low income already. live below the poverty line like many times we did, hence the 2 housekeeping jobs in the end. And so I really strongly encourage you to keep those folks in mind and please support AB 116. Thank you.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. This is Kendra Birchie with the Washoe County Public Defender's Office. Today I'm testifying on behalf of my office as well as the Clark County Public Defender's Office, and we strongly urge your support of AB 116. We believe that this is a very important step towards ending the criminalization of poverty. As you've heard from those before me, with just the amount of trauma that's involved with someone who wants to pay for their traffic ticket, but unfortunately, most of my clients are living paycheck by paycheck, and simply they want to pay their fees and fines, but because of the amount of interest and all the administrative fees, or having the additional fee to pay for a community service because they can't afford the fine, all these things just add up, and unfortunately, because they've already had that interaction with now the criminal justice system, we've seen that spirals. And what we've learned from studies is that the more times that someone has contact with the criminal justice system, even if it's for something as simple as a traffic offense, that leads to further interactions where it just spirals. And ultimately, it's honestly heartbreaking and more frustrating to have a mother or father in custody when you're trying to figure out what's going on for the bail hearings, where they're there because of a traffic infraction, or they're there because they had a few and just didn't know what to do and how to get out of that system. I wish, Senator Pickard, that my clients found that it was as easy as how you've explained it, and I can just say that from being here during this legislative session, I've had several members of this body ask me, or staff being like, I got a traffic ticket, what do I do? How do I resolve this? Where do I go? And so unfortunately, it's not as easy as we'd like to hope. And as we heard from even just attorneys, it's a frustrating process for attorneys to try to figure out how to navigate this process. So we do believe that this will be very important to ensure that people don't have to make that choice of are they going to pay their traffic ticket or feed their families for that week. The data shows that the effect of having this be a criminal penalty is ineffective and rather just has a crippling effect on our community members, which keeps them from engaging from the court. Our current structure creates a vicious cycle of crushing debt and prolonged involvement with the legal system, and I urge your support of this bill. Thank you.
Thank you, Chair Scheibel and members of the committee. My name is Benjamin Challoner on behalf of Faith in Action Nevada. I would like to echo the sentiments and comments from the previous testifiers. I won't add too much more, but on a personal level, I know what it means to get a traffic ticket and just have that snowball into something that becomes something you can't seem to know how to take care of. And so if we could get this taken care of so other folks don't have to experience that, especially those who are living paycheck to paycheck, that would be absolutely great. Urge your support. Thank you.
Thank you. Is there anybody else to give in-person testimony in support of AB 116? I don't see anybody, so we will go to broadcast, please.
Thank you so much, Chair Scheibel. To testify in support on Assembly Bill 116, please press *9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 116, please press *9 now to take your place in the queue. Caller with the last 3 digits, 800, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Good afternoon, Chair and committee members. My name is Amy Koo, AMYKOO, and I'm the Deputy Political Director of One API in Nevada. I first want to thank Assemblywoman Rochelle Wynn for presenting AB 116, which will help protect Nevada's immigrant communities. Under existing law, Nevada treats minor traffic violations as criminal charges. If someone gets a ticket for a broken taillight, for example, they have to pay the fines, or a judge can issue a warrant for their arrest. However, we know that many who are impacted by the fees for traffic violations are from the poorest zip codes in Nevada, and the payment plan for traffic fines disproportionately impacts communities of color. Decriminalizing minor traffic violations will ensure that we protect our communities and make Nevada safer for everyone. Thank you.
Thank you, caller. Caller with the last three digits, 080. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Hi, Jim Hoffman, representing Nevada Attorneys for Criminal Justice. NACJ supports AB 116. In the interest of time, I will just echo what other supporters of the bill have said. We do not believe that people should be arrested based on their inability to afford to pay traffic tickets. AB 116 accomplishes this goal and brings an important, meaningful amount of fairness to our criminal justice system. NACJ therefore supports it. Thank you.
Thank you, caller. Caller with the last three digits, 759. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Hello, my name is Jagada Chambers, Jagada, last name Chambers, Chambers. I'm a 89113 Nevada resident. I'm just calling, obviously, in support of AB 116. I think it's pivotal in the decriminalization of being poor. That's what it really is rooted in, folks. Whether you feel they're choosing to evade and elude police for previous fines or owed. Oftentimes, it really just boils down to the fiscal status of a person. I would petition this brilliant body to what does accountability and responsibility, how can that come from the cage? I think that's one thing that we have to hopefully elevate our thinking to understand that the cage is not going to relay any bit of responsibility to a person. All it does is impact families and cause more trauma. So if we were to get accountability for folks who haven't paid or make sure they are not running from their responsibility, how could this body think of a way to do that without a cage? I think that's the next step, if that is a linking measure. Again, I want to salute Assemblywoman Wynn for bringing the legislative forward, as well as the Honorable Chair for your joint sponsorship. Thank you so much for your time.
Thank you, caller. Caller with the last three digits, 035. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Good afternoon. For the record, my name is Quentin Savoy, Quentin, S like Sam, A like Apple, V like Victor, WOIR. I'm the Deputy Director at Make It Work Nevada. We are in strong support of Assembly Bill 116. We deeply appreciate the hard work of Ms. Mosley and Assemblywoman Rochelle Wynn in bringing this important piece of legislation to the forefront. This is a racial justice and an economic justice issue, and it will go a long way in making sure that the community members that we work alongside and organize don't ever have to have an entry point into the criminal justice system. We urge bipartisan support for this piece of legislation and appreciate your time.
Thank you, caller. Caller with the last three digits, 949. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
My name is Michael Kagan, Kagan. I'm the director of the UNLV Immigration Clinic. Chair Scheibel and members of the committee, I am speaking today for the UNLV Immigration Clinic. I need to say, for official purposes, I'm not speaking for UNLV or for NCHI. On a personal note, I want to say that I'm grateful to my own Assemblywoman, Rochelle Nguyen, for pushing forward this initiative. Our current system, which allows people to be criminalized, arrested, and jailed because they cannot pay a bill, makes our state unforgiving to people whose real offense is simply having less money. To create a crime, to authorize a person's arrest, their jailing, should be an exceptional choice by a legislature. Now, I need to say something about the impact of criminalization of traffic tickets for immigrant families. As you may know, any arrest into a jail in Nevada is often the first step into the deportation system and into immigration detention. The UNLV Immigration Clinic is one of the very few phone numbers that are given to people in immigration detention in Nevada. For the past few years, our receptionists have had to take the calls of people who have few other places to call, and they have asked people in immigration detention facing deportation how they got there. Too many times the answer has been that they were arrested for an unpaid traffic ticket. No family should be broken apart because of a traffic offense. I am not sure that when we are talking about taking away a person's liberty, that the question should ever be about monetary cost. But if we must, criminalization takes away a parent and a breadwinner. It turns an independent family into one that is helpless and dependent on the state and on other people. That is a cost. What is the fiscal note for the daughters who have been in my office not knowing if they will see their parent again? What is the municipal cost of a father missing the birth of his child because of a broken brake light? I hope at long last that we will join the majority of states that have decriminalized traffic offenses. Please support AB 116. Thank you very much.
Thank you, caller. Caller with the last three digits, 031. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Good afternoon, Chair and committee names. My name is Jocelyn Cuevas, Joseline, Cuevas, Cuevas, and I am an organizer at Mi Familia Vota. On behalf of Mi Familia Vota, we would like to express our support for AB 116. Many folks in the Latino and immigrant community are often put at great risk due to minor traffic tickets. This can lead to them losing their jobs, their homes, and we have even seen cases that lead to deportation proceedings. In the past year, we have helped folks that are eligible permanent residents and have become afraid to complete their citizenship applications due to minor traffic tickets because they will have to pay them off on top of their $725 fee for the N400 application. We must stop criminalizing hardworking folks due to their inability to pay off traffic tickets. AB 116 can help Black, Brown, and immigrant communities not fall into the criminal justice system. With that, we ask the committee to support AB 116. Thank you for your time.
Thank you, caller. Caller with the last three digits, 039. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Hello, my name is Erica Minaberry. That's ErikaMinaberry, and I am in support of AB 116. I would actually be testifying in person, but my license is currently suspended for a speeding ticket I got on March 16th, 2020, the day before the entire state closed down. The courts were closed at the time my hearing was scheduled. I am poor. I know Nicole Canizaro has claimed to grow up in a low-income household, so she should understand more than anyone that we don't have extra money to pay fines. We don't have access to credit. We have to choose between keeping our lights on or our children fed or to pay a fine. I know all the parents on this committee would always ensure the well-being of their children first, just as Canizaro's mom did with hers. Meanwhile, my entire life has been completely hindered because I went 5 miles over the speed limit, much as many of you did on your way to work this morning. Like many other poor people, I don't have consistent internet access. I don't have a computer. Like many poor people, I've moved several times in the last year due to the housing crisis, which is another issue that has not been addressed. And I just don't understand how Melanie Scheibel can brag about volunteering to feed the poor on her website while at the same time criminalizing being poor. I don't know if the members of this committee are too scared of their corporate overlords for when they're not in this session, but while we are in session, you're supposed to be working for us. And none of you have done anything for the people that are struggling the most in this state. And for the Democrats in the committee, you're expecting our votes in 18 months. The only reason why we've been keeping Nevada blue is because we have been voting for the lesser of two evils, hoping that you would do something for us.
I'm going to need you to stick to the policy.
The lesser of two evils, you're okay with
All
being
right,
evil.
we will move on to the next caller, please.
Thank you, Chair. Caller with the last three digits, 284. Please slowly state and spell your name for the record. You'll have 2 minutes to speak. It may begin.
Good afternoon. My name is Brandon Summers, BRANDONSUMMERS. I'm a resident of Las Vegas. I'm in support of AB 116. Traffic tickets should not turn into criminal cases because the folks can't pay the fines. When you don't have it, you don't have it. When you're poor, when you're broke, taking care of bills and debt becomes exponentially harder to do. And personally, I'm paying rent and putting gas in the car before anything else. Though I've never had a traffic ticket in the state of Nevada, I have been arrested on a misdemeanor bench warrant. And thankfully, I was able to bail out after 12 hours. But the time in CCDC did not help me, and I'm glad it didn't cause any more collateral damage to my life and employment. But being locked up made it harder to pay my fine because I spent $450 on a bail bondsman. Again, I'm in support of AB 116.
Thank you, caller. Caller with the last three digits, 399. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Thank you. Good afternoon. My name is Anne Traum, ANNE-TRAUM. I co-direct the UNLV Misdemeanor Clinic and strongly support this AB 116, and I'm grateful to my Assemblywoman, Rochelle Wynn, for bringing it forward. I wanted to highlight and echo some of the stories we've heard this morning by talking about two of my clients who I met at a warrant clearing clinic back in 2018 at the Doolittle Community Center. The first woman was a mother who was in her late 20s and had gotten a $600 ticket that she, when she was 18 years old, that she had never paid because she was afraid to pay it. As she entered the building that morning with her children in tow, they asked her if mommy would be arrested and taken to jail that morning. So it just showed how the ticket was more than just an unpaid debt. It was a source of fear for the whole family. And when the ticket and the warrant were cleared, the mother just burst into tears because a cloud had been lifted in her life. Another client was a grandmother who had more than $5,000 in fines and fees just from a couple of tickets that had spiraled. And she had already gone to jail once and could not go again because she had to care for her disabled grandson so that her daughter could go to work. And she couldn't afford the $50 payment plan, which is the only option that had been given to her by the court. So we eventually helped her negotiate a path forward where she could spend her money on actually reinstating her driver's license. And eventually she put the whole saga behind her, but it had taken more than 5 years. Without counsel, these people are really kind of helpless in front of the court, and they don't have all of the options that are available to people with counsel. Our clients fall into a cycle of debt with one or two tickets, and then they can't recover, and it takes them years. So we're strongly in favor of decriminalizing traffic offenses. It would lift a burden of that's psychological, that's financial, that's generational on these communities who are hardest hit. And it's also fair, just, efficient, and humane, and the right thing to do. So I thank you for the broad support that I've heard, and hope that this moves forward. Thank you.
Thank you, caller. Caller with the last three digits, 963. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Hello, my name is Yesenia Moya, YESENIA MOYA. I would first like to thank Lisa Mosley and Assemblywoman Wynn for helping to present this bill again today. I'd like to address Assemblyman Pickard, who asked the same question that he asked me the first time that we presented this bill. I had about 4 or 5 different traffic tickets throughout the last 5 years, and I was never able to see a judge. Even when I asked, I was told at the window that I couldn't. I was afraid to go to the window because I was told that if I went to the window, I would be arrested if I didn't pay off the entire fine. I also heard somebody say that there's a minimum, like $10 a month for a payment, and I've never heard of that. So if anybody is a plug on this call, please hit me up, because $10 a month would be very helpful to pay off these traffic tickets. In December, I was able to pay off all of my traffic tickets thanks to Vegas Freedom Fund. And even though I paid them, a week later, I was stopped by a police officer who just scanned my plates. I did absolutely nothing. All he did was scan my plates, and he said that they were suspended, and he took my plates. The next day, the DMV fixed it because they saw that it was a mistake on their part, where there was no communication. I think it's extremely absurd that the court and the DMV will talk to each other when somebody is automatically put into warrant, but they won't talk to each other when they've paid off a fine. And so I ended up not only having to pay another traffic ticket for driving without a driver's license, but also have to go in again and go through the entire process of having to get my driver's license and my license plate. And I'm still in the process of getting my driver's license. And this has been 5 years now in the running. I have gone to warrant quashing clinics.
2 minutes, if you could please wrap up.
And I'm finishing. Yep. I've gone to warrant quashing clinics. I've gone to the window. I've gone to lawyers. I've gone to nonprofits. I've tried to do it myself. It is almost next to impossible to pay off traffic tickets. Thank you. Please.
Thank you, caller. Caller with the last 3 digits, 767. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Hi, my name is Tanisha Freedom. T for transform, E for energy, N for noble, I for impeccable, S for strength, H for honest, A for abundance. Freedom for free them all, let the people sort them out. I'm a grassroots organizer in the Las Vegas community and founder of Organize the State Out Coalition. After 30 years of driving, I feel that I'm a professional driver. And a lot of people on our roads are. We should be able to travel in safe sunlight conditions, a few miles over the speed limit without being targeted, profiled, and harassed by local police, which is absolutely what happens in Black and brown communities constantly. And then further, we get entrapped in financial hardship. Being poor people and in the financial raping really of our community. So we need to stop making poverty a crime, as others have testified on this call. We're scared, literally scared to walk into these courtrooms to address even some of these fines at times when they get out of hand, when we know there's been extra fees, when we know there's been a warrant issued. We're fearful and scared when we get pulled over during these traffic stops for non-violent, non-community safety issued violations. That we're actually scared, and it's disgusting that this has become the face of, so-called justice and liberty within the state, within the city, and across this country. The police should absolutely stop pursuing minor traffic tickets and minor traffic infractions in full. Altogether, we also support of decriminalizing, of course, of this bill, decriminalizing traffic in regard to this bill. I've entered, the court cash machine before, also known as traffic court. And the concern is not safety. The concern is money. Within an hour, 100 plus people are rapidly pushed through a plea process where it's usually dropped down, charge, and it's negotiated to a dollar amount. So it's just a change.
You've reached 2 minutes. If you could please wrap up.
Yes, I want also say that we should take the criticism for the 2 minutes of the voices of the people. I've heard 1 or 2 people get cut off due to their passion in regards to the issue. Listen to the people, listen to our voices, and don't cut anybody off during this forum. Thank you.
Thank you, caller. Caller with the last 3 digits, 247. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Good afternoon. For the record, my name is Erika Castro, ERIKACASTRO, and I'm here on behalf of the Nevada Immigrant Coalition in support of AB 116. The Nevada Immigrant Coalition supports because it would decriminalize traffic tickets, keep our community members out of the jail system, and prevent Nevadans with sensitive immigration statuses from ending up in the deportation pipeline due to unpaid traffic tickets. From January to September of 2018, there were 138 instances in Henderson and in Las Vegas jails where ICE holds were put on someone whose most serious charges were traffic violations. Some of them had broken bicycle lights, while others were charged with jaywalking. Your support for AB 116 would ensure that families are not torn apart because of a traffic violation, and that we also take a step towards ending the criminalization of poverty. We urge you to support AB 116. Thank you.
Thank you, caller. Caller with the last three digits, 556. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Anne Marie Grant, ANNEMARIEGRANT, sister of Thomas Purdy, murdered by Reno Police in Washoe County Sheriff's Office. I'm in full support of AB 116. It's time to stop criminalizing poverty, and please support the bill. Thank you.
Thank you, caller. Caller with the last three digits, 283. Please press *6 to unmute yourself. Thank you, caller, and slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Marcos Lopez, Americans for Prosperity, Nevada, MARCOS, LOPEZ. Americans for Prosperity is proud to support AB 116. We just want to echo a lot of the same statements that were made, but in particular, we believe this is a good step forward because requiring law enforcement to execute warrants for unpaid traffic tickets distracts them from activities that can improve public safety and can unnecessarily rob individuals of opportunities to improve their lives, particularly those that are already struggling. Such actions waste time and resources and lead to unnecessary contacts between citizens and the police and can erode trust between the community and law enforcement. We hope that everyone can support AB 116. Thank you.
Thank you, caller. Caller with the last three digits, 766. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Hi, yes, my name is Matthew Wilkie, MATTHEWILKIE. I live in Assembly District 40. I do want to echo all the callers before me. We need to stop prosecuting and persecuting being poor. You cannot get blood from a rock. I do want to thank Erica and for her testimony. And I do also want to add that when you start a committee meeting hours and hours late, it kind of prohibits people who work during the week to jump on and make testimony. I do want to say thank you to my friends who contacted me to let me know that public testimony, that public testimony was happening. But I do urge your support for AB 116. Thank you.
Thank you, caller. Caller with the last three digits, 106. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Hi, my name's Emily Driscoll, EMILY DRISCOLL, constituent of Chris Brooks. I'm only in support of AB 116. And I am a rising third-year law student at Boyd, and my short experience in the legal profession has been pretty world-shattering in that it put me in proximity to put me in a better understanding to be to understand how we treat people in this state, and it is so wrong that someone would have to spend time in jail because they can't pay a traffic ticket. And I think that if we were to pass AB 116, it would really show our humanity and empathy for poor people. beyond, the burden that it places on our courts and on our taxpayers to house people in jail for minor infractions that realistically hurt no one. I yield my time. Mommy!
Thank you, caller. Caller with the last three digits, 922. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Ender Austin III, ENDER, AUSTIN, III. Good afternoon, members of the committee. Senator Canataro, my wife and boys were actually in one of your campaign pictures. Dallas Harris, Senator Harris, my friend. And just so y'all know, I really am bipartisan. Scott Hammond, my friend as well. I want to talk to you not about, and I represent Faith in Action Nevada, and I want to talk to you not about the folks that got organized, because we already had one of our other colleagues, Ben Chalonar, to talk about our organizational stance. But I want to talk to you about my personal stake in the ground here. Right before I went to college, that summer before, I got a silly traffic ticket, and because I was in school, simply forgot to take care of it. Fast forward about 7 or 8 years down the road, I was on my way to church to direct the choir in a suit. My wife was driving. We were pulled over, and the officer took me out of the car. Even though he had told my wife everything was fine, another officer came and asked me for my driver's license. I said, "I'm not driving. Why do you need my license?" He said, "I don't know who you are." After he interrogated me, eventually found out I had a warrant, which I told him when he asked, put me in the back of his car. And then as he drove away, he called his girlfriend to say, and I quote, "Hey, babe, I made my first arrest." There are so many other things that could have been done with my tax dollars, as someone excitedly reported to their girlfriend about arresting someone over an old traffic ticket because I was too broke to pay it. Fast forward a few years down the road, and I'll talk to you about the fact that I sent a group text message to my family with tears in my eyes because I had reached a point in my professional career where I could pay off all of the traffic tickets that I had incurred over the years. This is a racial justice issue. We know that people of color are more likely to be pulled over by the police. And as much as we need to decriminalize, we also need to have a firm conversation about the monies that have been extorted from communities of color because of these actions. Thank you so much. And I pray that you all have a heart and support this bill.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to provide support testimony at this time.
All right. Thank you so much, Mr. Kyle. So in case any of you missed that, we have heard testimony from everybody who called in to give support testimony. And that brings us to opposition testimony. Is there anybody in the room to give opposition testimony? I don't see anybody coming to the table. So we will go directly to opposition testimony on AB 116 via the phone.
Thank you so much, Chair. To testify in opposition on Assembly Bill 116, please press *9 now to take your place in the queue. Once again, to testify in opposition on Assembly Bill 116, please press *9 now to take your place in the queue. Caller with the last three digits, 249. Please press *6 to unmute yourself. Thank you, caller, and slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Joseph Lankowski, JosepHlanKowski. Somehow I got skipped on the last bill, so I'm going to use this time to say that I'm in support of that bill. For many reasons, traffic tickets do not belong in criminal courts. For example, if we were to have been as late as y'all were for this meeting, we would get a warrant over a petty traffic infraction. So that, first of all. Another reason is what happened to me. As somebody personally impacted by how broken this system is, I got a speeding ticket for going 5 over the speed limit My lawyers took care of it. This was in Jean, going out to see the Seven Magic Mountains. And the lawyers took care of it. Jean Court sent something to the DMV. The DMV somehow didn't enter it into their system. So because this is all in criminal court, I ended up getting pulled over, and they said my license was suspended, which it shouldn't have been because it was taken care of. My truck got towed because it wasn't registered because the DMV, I had a DMV appointment, but it takes so long to get to the DMV right now. Like, it's just a mess. Traffic citations do not belong in criminal court. People are suffering every day, and it's costing even more money than just the fines you're trying to extort out of people. So I also believe that if the money stays out of the criminal courts, then maybe it'll deter road pirates from trying to extort further funds from the community. Thank you.
Thank you for your testimony, and if the record could please reflect, that was Joseph Lankowski and his testimonies in support. And we'll continue with opposition testimony at this time.
Thank you, Chair Scheibel. Once again, we are currently on opposition testimony for Assembly Bill 116. If you'd like to provide opposition testimony at this time, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide opposition testimony.
All right, thank you so much. So again, we have heard everybody who wanted to speak in opposition, and that brings us to the neutral testimony on AB 116. Anybody in the, I see a couple people in the room to give neutral testimony. We'll start with you.
Thank you, Chair, members of the committee. Chuck Calloway for the record, representing the Las Vegas Metropolitan Police Department. We are neutral on the bill. We're not opposed to traffic infractions being civil in nature. We understand that, especially after AB 236 last session, that the idea that someone could steal $1,200 worth of property and that would be the same offense as rolling through a stop sign does bring to light the question of whether or not these should be civil versus criminal. Our concern with the original bill lied in the fact that we want to ensure that officers in the field operate the same, that we have the ability to conduct traffic stops, that we have the ability to impact bad driving. This year, to date, we've had 50 fatalities on our roadway compared to 39 at the same time last year, and it is important to be able to curb behavior on our road to ensure that our roads are safe for everyone. If the court chooses to treat these offenses as civil, we're not in opposition to that. The way the bill has been drafted since coming out of the Assembly provides us a much higher level of comfort with the language. We appreciate Assemblywoman Nguyen working with us on that. I looked into briefly the question that was raised about enforcement, and NRS 289 outlines the categories of officers and what their duties are for Category 1, Category 2, and Category 3. And NRS 484A outlines the issuance of citations. This bill actually amends NRS 484A. And then in talking with Assemblywoman Nguyen prior to testifying, we had discussed how local ordinance, we believe, give the meter readers the ability, or civilians in some cases, the ability to issue a parking citation, such as parking in a handicap zone. And so I believe that local ordinance would be able to provide that ability for parking citations. And I'd be happy to answer any questions. Thank you.
I don't see any questions from members of the committee, but thank you for the offer. Go ahead.
Good afternoon, Chair Scheibel, members of the Senate Judiciary Committee. Alex Ortiz with Clark County. Clark County is neutral on AB 116, second reprint, as proposed to be amended. The amendments that we see make the bill better for us and actually help reduce our fiscal note as well. We also do support the public policy of making most traffic violations a civil infraction. The county, however, will lose some revenue from canceling the outstanding bench warrants issued for a traffic citation before January 1st, 2023. That said, we want to thank Assemblywoman Nguyen for working with us these past few months, listening to our concerns, addressing them, and keeping the conversation going on this important issue. We appreciate her efforts to some of the numerous stakeholder groups and getting us to this point. Thank you for your time this afternoon.
Good afternoon, Chair Scheibel, members of the Senate Judiciary Committee, Dagny Stapleton, Executive Director of NACO, the Nevada Association of Counties. We are neutral on the bill. We want to thank the Assemblywoman for working with us. We were previously opposed, but not based on the policy changes in this bill, but only based on the fiscal impact. With the amendments, the fiscal impact has been significantly reduced. There are some outstanding fiscal impacts, but again, we are now neutral on the bill. We want to thank the Assemblywoman for accepting our amendments, and we know how hard she worked and how many stakeholders she worked with, including us, and we wanted to express our appreciation for that. Thank you.
Thank you, Madam Chair, members of the committee. Warren Hardy, today representing the Urban Consortium, which is made up of the cities of Las Vegas, Henderson, Reno, and Sparks. We are too, as well, neutral on the bill. I would just associate myself with the comments that have been made by my colleagues from local government and express our appreciation for Assemblywoman Nguyen for her the time she spent talking with us. You know, anytime we do policies like this, we drop a pebble in a policy pond that ripples out, and one of those ripples is the need to implement the policies that this legislature passes. And we've had several of those this session, Madam Chair, members of the committee, and we just ask the committee to be mindful as we move forward to not pass this policy and then forget about the implementation and the expense that's associated with it. We've been very careful as members of the Urban Consortium to make sure that our fiscal note is not overblown, but is given it with the best, most accurate information we have available. And this, along with every other bills, are going to have implementation expenses. We don't have any objection to the policies that's being presented here, but ask this legislature to look at this as we go forward, as we implement these policies at the local level. And I know we're continuing to work with the sponsor on a conceptual amendment to allow us to collect the current outstanding amounts that Mr. Ortiz spoke to, and we would certainly appreciate that. But as it stands today, we're in neutral and appreciate very much the sponsor's willingness and the countless hours she spent working with us. So thank you, Madam Chair.
All right, I don't see anybody else in person to give neutral testimony, so we will go to the phones for neutral testimony on AB 116.
Thank you so much, Chair Scheibel. To testify in the neutral standing on Assembly Bill 116, please press *9 now to take your place in the queue. Once again, to testify in the neutral position on Assembly Bill 116, please press *9 now to take your place in the queue. Caller with the last three digits, 196. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Good evening, Chair Scheibel and members of the Senate Judiciary Committee. I'm Eric Spratley, S-P-R-A-T-L-E-Y, for the Nevada Sheriffs and Chiefs Association, here neutral on AB 116. I did point out that where the amendment refers to badge number of the peace officer, that sometimes that's not as accurate as a personnel number because badges sometimes change for various reasons, promotions and such. So any accommodation there for an identifying number or whatever would work out. It's the pleasure of the committee, I guess. So we're neutral on the bill. Thank you, Madam Chair.
Thank you, caller. Caller with the last three digits, 034. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Jack Esslinger, J-A-C-K-E-S-L-I-N-G-E-R. I am the court administrator for the Las Vegas Municipal Court. Should the legislature elect to pass this legislation, the Las Vegas Municipal Court is prepared to move forward with implementation. As the court administrator, I'm duty-bound to report the following. There will be costs to implement due to reconfiguration of existing case management systems, and it will take time to accomplish this as well. Municipal courts typically do little to no civil processes, so the courts will have to design and implement entirely new procedures and processes. These operations will be at higher volumes and will involve substantially more than parking ticket collections. We like the Arizona model, and the ability to suspend a driver's license is critical to that model and to us. I know this bill allows for the suspension of driver's licenses, but there are other standalone bills still active that will prohibit the courts from suspending driver's licenses. As a reminder, Arizona and other jurisdictions are also allowed to attempt collections of people's state income tax returns, which obviously we cannot do here in Nevada. If we can't suspend driver's licenses, any subsequent civil citations are merely added to the collections efforts already underway. This means there is little to no deterrent at this point. If they don't care about $250 in collections, the next civil citation won't mean anything either. With the legislature's passage of AB 434 from last session, which was deeply impacted by the pandemic, and we're still measuring its impact as we move forward, plus other efforts this legislative session, we hope that the legislature appreciates how the overall legislative picture is impacting the various court systems. We too would like to thank Assemblywoman Nguyen for working with the courts so effortlessly on this legislation, and we very much appreciate all of her efforts in hearing us and implementing some of our recommended changes. In conclusion, Madam Chair, let me reiterate that we are prepared to move forward, but I appreciate the opportunity to relate the court's position on this bill. Thank you, and have a great.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to provide neutral testimony at this time.
All right. And with that, we have heard testimony in the neutral position from everybody wishing to give testimony. So that concludes all of the testimony on this bill. I see our sponsor coming back. And if Ms. Mosley would like to come give some closing remarks, that would be the time.
If I could also, I'm sorry, Rochelle Wynn for the record. Thank you for this opportunity. There were a couple of things that I did want to clarify that kind of came in kind of last minute that I would like to incorporate in any potential work session document as a part of some additional amendments that came forward. Pursuant to NRS 484B.467, this was unintentionally left out of the civil infraction. This is parking in a handicap zone. So I would like to propose an additional amendment that also makes that a civil infraction. Again, I would concur with what we had contacted legal counsel from Mr. Anthony with regards to Senator Settlemeyer's question about that, and what Mr. Callaway had represented is correct. Those parking ordinances and all those things would remain under the jurisdiction of local ordinances. However, the ability for those traffic violations and those active moving violations would remain with peace officers under this bill. Additionally, I think there was one other change that came from the courts of limited jurisdiction, and if you'll bear with me for a minute, I'll make sure I get that in here because I think that's important as well. I know that the Nevada judges of limited jurisdiction also called to my attention that particularly in smaller townships, there is either no or limited mail delivery, and the recipients must go to the post office to collect their mail from the post office box. Hence, Section 27.1C, we will work on language to amend that if the mailing address is different from the residence address, both addresses must be listed, and we will work on the wording of that. I know that that was something that they brought to our attention, and we are amenable to that amendment as well. I would just point out, I know that there were a lot of people that talked about the misdemeanors. We heard testimony in 2019 when this bill was heard then from a string of medical students and people trying to go into the medical profession. And I'm sure that the lawyers on this committee that applied for the bar exam knew that they also had to list on their applications all criminal misdemeanors that they had, and that did include traffic tickets. I will say I had to put one on myself. So to put that on there, and I know that that has also been an impediment, and it was something that in the 2019 session, we heard quite a bit of testimony from those individuals. We're always trying to get professionals in here, medical professionals in particular, and this would also eliminate that further hump that is causing people not to get occupational licensing, not get into past bar licenses, and just as another hurdle that people would have to overcome. And implementing 116 would be a step in a right direction for our policy. Oh, in addition to the amendment, I did get a text message from Senator Hammond that he would like to be amended on as a sponsor. And since I am also making those other amendments, if there are other individuals that would like to be, I see Senator Harris and Senator Orenshaw that would like, and I see Senator Pickard that would also like to be added as co-sponsors, and I'm happy to do that. And if there's any others, please let me know. Thank you.
Lisa Mosley.
I just want to thank you, Assemblywoman Nguyen, for working with the Fines and Fees Justice Center so closely, as well as other folks, in bringing this legislation back again, and I believe to finally get it passed. I want to thank you, Chair Scheibel, and members of this committee for listening to all of us and taking into consideration the testimony that we've offered here. And I want to shout out Scott Hammond. Senator Hammond is my senator, so I want to say thank you. You know, that shows my nonpartisanship too. And to all of you all who offer testimony, it is absolutely time for Nevada to join the other states who have passed this legislation, increased revenue to their state, and made it a lot easier for their residents. I want to say that if we continue to do things the way that we've always done it, we're going to continue to get the same results. There is nothing wrong with trying this and working out the kinks as we go. So I urge this committee to pass this legislation, and let's go, Nevada. Let's do it.
Thank you so much, both of you, for your presentation, and to our other presenter whose name I've forgotten. Ms. Ferris, thank you, and everybody who came in to testify and join this conversation. I will now close the hearing on AB 116. I will now open the hearing on AB 404.
All right. Bailey Bordelin, for the record, representing the Nevada Coalition of Legal Service Providers. I have been working with Assemblywoman Bilbray Axelrod primarily on this bill, but she is not able to join us, so I will just run through it quickly if that's okay. This is a bill coming from our domestic violence attorneys that I represent and work with, and these are two fairly well-vetted concepts in the domestic violence legal community that have not raised any opposition or concerns thus far. And so, to give you a very quick lay of the land, Section 1 adds some venue to where a victim of domestic violence may apply for a protection order. Our statutes were silent on it before, so this will bring some statewide consistency. And what we see oftentimes is someone will have a situation where the abuse may have occurred out of state and they are sheltering in Las Vegas, for example, and the court may believe that it needs to have occurred here, but it's kind of a moving target depending on which judge you get or which court or which community you're applying in. So this will close the loop. I did on Nellis attach a chart that showed that 31 states had this venue as of 2009, which is very outdated, so I can assume there may be more since, but this is a fairly standard practice to apply in this area. And then the other piece is adding that if the applicant reasonably believes disclosing his or her address and contact information in the application would jeopardize his or her safety. This is codifying our confidentiality standards for our TPO process. This is something we've talked about for a really long time. We've tried to solve this problem in a lot of ways, and I will admit this may not be perfect, but this is codifying what the legal community is currently doing in this area because of the safety threats that exist. And it's one of the only areas where we have successfully implemented a statewide form. So there is a statewide form for a domestic violence protection order, and that form does allow for this language, but we felt it was a better practice to have statutory authority for that practice because sometimes when the bench changes or when things change, we rehash the conversation of, is there a perfect way to do this? And we end back up on this practice. So with that, I'm happy to answer questions.
Thank you so much, Ms. Bordelin. Are there questions from members of the committee? Senator Pickard.
Hey, Madam Chair, and thank you for addressing this. I agree. Having handled a number of, probably 30% of my practices is dealing with victims, not all victims, but it's sometimes the adverse party. And it's always within the context of a custody case. or at least a divorce case. But it's regarding the custody issues that I'm most concerned. When I'm looking at Section 1, Sub 2, where we're allowing someone to file where they have fled to, I certainly see the benefit for that, right? But the inconvenient truth, to borrow a phrase, is that there's a good proportion, though small, that is that they use TPOs or allegations of domestic violence in order to gain an advantage in the custody case. And I just finished right before session a trial where, in this case, Dad had gone to Missouri and filed a TPO action there, and it resulted in depriving Mom of who I represented of contact with the child for 9 months, only to find out that it never happened. In fact, there was evidence showing that he wasn't even in the state at the time he alleged the violence had occurred. So I'm really concerned, and because it was in a state other than where she resided, it made it extremely expensive and difficult for her to defend. How do we, and because this is silent as to what the standards are for the court to consider when allowing an applicant to file in a jurisdiction other than the jurisdiction in which it occurred, and given the due process concerns that we have, being able to confront the evidence and the witnesses and that sort of thing, how do we square this with the adverse parties' due process rights, and how do we avoid this being used as a mechanism, particularly in custody cases, where it will provide a significant litigation advantage to the applicant? How do we square all that?
Bailey Bordelin for the record. Thank you for the question. I think also practicing in this area, it's a hard one where there's no perfect answers because it's often he said, she said. Because the law is currently silent on this, I will say it is my good faith belief that most courts are already allowing this in Nevada, but there is not statewide uniformity on the issue. So you're kind of gambling if it's worthwhile to pursue because the law is silent on it. So I believe that there is value in adding this and that value outweighs the risk, because if the person didn't have the evidence, the court doesn't have to grant the TPO. The court still has to look at it in any other situation. And importantly, it's not the custody case, it's this situation. But especially this year, we've seen DMV delays, right? So there are people who have really come here, who really live here, and this is their community, but they're having trouble proving that to the court because they don't have a driver's license in Nevada yet, but this is now their home. But we also, the problem that this is solving, I think, is let's give access to justice and let's let people apply, and then let's apply the legal standards where it should be granted or not, because we're not looking at the merits of the case, where we have cases where a judge in Clark County says, I don't think I have venue, hands up, and they go back to their community in New Mexico, and New Mexico says, well, we don't think we have venue because you've moved to Clark County. And we have those cases where they get bounced and they're never able to access the protection order in any venue.
Well, and I certainly appreciate that. I happen to have handed off to another attorney in my office a case on the opposite side. The parties had moved to Oregon. They got into, and there was domestic violence throughout their relationship. And then he came back here and filed here, and somehow Nevada, they'd already moved out, and Nevada had taken jurisdiction. So there are certainly courts that will handle this differently, and I appreciate that. And I do also appreciate that this is permissive language, and they will still have the ability to decline to issue the protective order if they don't think that there's sufficient evidence. But this is, I mean, it's satisfaction of the court. It's the lowest standard we have. And so basically, if they come with any evidence at all that the violence has occurred, now they're going to have the ability to obtain the order. And so I'm just a little concerned about, since the bill doesn't set the standards, that we're giving them not only the permission but the guidance necessary, because this is what we hear all the time. Once we leave the legislative building and we go back to the judges, and I'm sure you hear this too, the judges will ask, why didn't you give us guidance? Now it's, up in the air. Now we leave it for the courts to decide. But I think you've put on the record really what I was aiming at, which is it's permissive. The court still has to look at the evidence. They still have to go through the analysis and then decide. So I think I'm satisfied. I just wanted to make sure that we're clear on the record what the intent is, and that the courts do still need to look at the evidence, make sure that there's sufficient evidence, and particularly within the custody issues, that the court will also be looking at things like what are the motivations that the applicant may have outside of actual protection order. Those are all important things to consider. So if those are, if that is the expectation, I think I'm okay. Thank you.
Okay. Any other questions from members of the committee? I don't see any. So thank you so much for your presentation. We'll move on to testimony in support of AB 404. I see somebody here in the room to give testimony, and you may go first.
Thank you, Chair and members of the committee. For the record, my name is Tess Opperman, speaking on behalf of the Nevada Women's Lobby. We are in full support of AB 404, which helps give clarity in NRS for where a person is able to apply for a temporary protective order. This is critical for victim survivors of domestic violence who may have fled their abuser for safety and may be staying in an address outside of the county or state in which they reside. This also gives necessary protections for those who are not able to disclose their address for fear of being found by their abuser. These are important measures to be codified into state law. We urge your support, and we thank you for your time hearing this bill.
Thank you for your testimony. I don't see anybody else in the room, so we will go to testimony by phone in support of AB 404.
Thank you so much, Chair Scheibel. To testify in support on Assembly Bill 404, please press *9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 404, please press *9 now to take your place in the queue. Caller with the last three digits, 540. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Good evening, Chair Scheibel, members of the committee. For the record, my name is Serena Evans, SERENA-EVANS, and I'm the policy coordinator for the Nevada Coalition to End Domestic and Sexual Violence. This bill is long overdue, and we're pleased to be here in support of AB 404 today. Over the interim, we at the coalition worked closely with Bailey Bordelin and other legal aid attorneys to address the safety concerns addressed in this bill, and we're so grateful for Assemblywoman Bilbray Axelrod and Bailey for bringing this important bill forward. Victim survivors should not be fearful that a necessary and helpful tool for protection could in fact cause more harm than good, and they should be allowed to withhold their personal information from an adverse party in certain and extreme cases. The time after a victim survivor leaves is the most dangerous time in an abusive relationship, and so victim survivors should have the ability to relocate and obtain new housing that is undisclosed to the perpetrator without having to disclose that information when filing a protection order, or refrain from getting a protection order altogether as a means to bypass having that information shared. Many times after enduring and fleeing abuse, victim survivors seek safety and refuge in a new county or a new state, and this important piece of legislation would make sure that all victim survivors can seek safety anywhere in Nevada, regardless of where their abuse took place. Again, I want to reiterate that this bill will create a long overdue and necessary changes to protect victim survivors, and we encourage your support of AB 404. Thank you.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to provide support testimony at this time.
Thank you so much. We will move to testimony in opposition to AB 404. I don't see anybody in the room to give testimony, so we will go to the phones, please.
Thank you so much, Chair. To testify in opposition on Assembly Bill 404, please press *9 now to take your place in the queue. Once again, to testify in opposition on Assembly Bill 404, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide opposition testimony.
All right, we will go to neutral testimony on AB 404. No one's coming to the table in person, so we will go directly to the phone lines, please.
Thank you, Chair. To testify in the neutral standing on Assembly Bill 404, please press star 9 now to take your place in the queue. Once again, to testify in neutral on Assembly Bill 404, please press star 9 now to take your place in the queue. And Chair Scheibel, at this time, there are no callers to provide neutral testimony.
All right, thank you so much. That concludes the testimony. Unless the sponsor has anything further to say, that concludes the hearing. I will now close the hearing on AB 404. We will not be work sessioning these bills today as we have another meeting coming up tomorrow, which you will notice the agenda has been posted. It will not necessarily begin at 1 p.m., but upon adjournment of the floor. So I appreciate everybody's staff and everybody keeping in touch to make sure that we all get here at the same time, whenever that time is. And with that, for today, we are adjourned. Oh, no, we're not. We have to make public comment. Is there anybody here to give public comment? I don't see anybody here, so let's go to the phone lines.
Thank you, Chair Scheibel. We are currently at public comment this evening. If you would like to provide public comment at this time, please press star 9 now to take your place in the queue. Once again, to provide public comment at this time, please press star 9 now to take your place in the queue. And Chair Scheibel, the public line is open and working. However, there are no callers to provide public comment at this time.
All right, then. We really have come to the end of the meeting, and we are now adjourned.